nurture that issue to a large extent. Sir, I started my career as an income tax consultant, and therefore I was exposed to ITA. I think all of you will agree that ITA tribunal is the best, and statistics says that almost more than 90% of the cases decided by RTA defense are ultimately approved by the apex court. That's the statistics of the income tax tribunal. Sir, I mentioned to you to enlighten these participants where do you stand as far as the RERA tribunal is concerned in this context, and what do you think, what are the pros, minus, and plus, and how do we take it to that? So the RERA is very, very important statute. We knew the position of the Kota. RERA is going to help and create public opinion. Just now we are discussing institutions should be part of the agreement for the success. So sir, I will consider this request and throw some light on this aspect. Sir, I now hand over mic to Ramesh Prabhu for conducting that. Thank you. Thank you very much. I welcome future officers and each of the participants. Today's chief guest, Gautam Chatterjee, Dharmendra Sharma, President of Rotary Club Bombay, Ashwin Bhai CA, Ashwin Shah, Nitin Sampath, Advocate, as well as CA Sunil Sharma and Arun Gupta, and all the participants, of course, Suzar. So we have been conducting this program regularly. I once again welcome each one of you. And now I request the President of Rotary Club Bombay West to enlighten us, and then of course we'll definitely get enlightenment from the views of Gautam Chatterjee. Thank you. Thanks, Ramesh Prabhuji. Good morning, friends. First of all, thank you very much for to be here on a Sunday morning on the rainy day and Ganesh Chaturthi, Visarjan day of the 5th day. So I welcome you all on behalf of Rotary Club of Bombay West. So this is the second oldest club of the district, and Lemon Housing Series 2.0, which is our housing exhibition and conference, which we have been running for last 5 years. This is the 5th year going on. So apart from this, we are into a lot of community service. As you know, this building itself has 2 banquet halls, and we are running a medical center at a very discounted rate. All the services, 109 services are provided to the community. So please spread the awareness, and so maximum people can be benefited. Discounted rates are there, even special mental wellness, skin, pets lab, physiotherapy, and all are just less than half the rate of the market. This coming Wednesday, we are having a special workshop in 7:30 p.m. onwards, where we have recently purchased a defibrillator, which is a heart start machine. So, a cardiologist from Bridge Candy is going to conduct a workshop. So, if anybody is interested, please do come, because we never know that we can become an instrument to save somebody's life. So, not taking much time, I would hand over the proceedings to Ramesh for the session. Yeah.
Good morning, Andheri President, my friend Ramesh Juhu, Karanji, Ashwinji, Sampath, Sharma, and all the Rotarians. It's a pleasure to be back here speaking on a subject which has been very close to my heart. I recall about 3-4 years back, maybe, I was here, even earlier, when RERA had just been introduced, and I was then requested by the then President that members would like to understand the various nuances of the new Act. As I speak here today, you are aware that RERA, which has been a game-changer legislation in the real estate sector, has just completed 5 years of its implementation. And we all feel proud here in Maharashtra that Maharashtra has been leaders in the implementation of this Act. It is often said in our country that we do have very good legislations, very good acts, but the Act does not remain good because its implementation is usually marred by various problems. So implementation, including the point that you also raised, that when an act is being interpreted by a tribunal or an appellate body, and that interpretation is upheld in the highest forum of justice, then that is also a part of good implementation of the act. And therefore, the whole idea in setting up of this institution called MahaRERA, the Maharashtra Real Estate Regulatory Authority, was certainly that it should be such that the act is implemented in letter and spirit. It is an act of only 92 sections, a small act, and whatever is written in black and white is read by all in country. But then ultimately, I would take this opportunity to pinpoint as to what are the fundamental issues that were maybe in those 92 sections, which is not very evidently visible in the writing of the act. Now, the background to this whole thing of bringing in this new act and bringing in regulation in the real estate sector was that this sector, called the real estate sector, is very close to everybody's heart. Each one of us, at some point of time, either we have purchased a home or in our expanding family we are intending to look for that second home for the national growth of the family, or maybe also as a source of small investment if there is some money that is there, whether we should put the part of the money in buying some yellow metal or putting it in mutual fund, or should we go in for something which is more tangible like real estate property, is a thinking that is occupying the thinking process of each one of us. And therefore, this sector, which is very important from the national GDP point of view, contributing 8% to the GDP, very important from the point of view of creating employment in the country, second only to agriculture, a sector on which 250 plus ancillary industries are dependent. Cement, steel, paint, and you name it. Each one of these industries will depend on the success of a real estate sector. And most importantly, 77% of the household assets are held in real estate. So, 8 out of 10 rupees that we have at any point of time in this country is actually held in real estate. So, that's the importance of this sector. But in spite of this, there were umpteen number of problems. Maharashtra was fortunate to have a 1963 Act called MoFA, but the implementation of that Act was again marred by various problems, and therefore people never used to get the fruits of the benefit of whatever are their provisions of this MoFA Act. Now, what were the problems? If I have just put it down in a brief, first problem was what I often say, information asymmetry. That means as a home buyer who is trying to put in his life savings, total money that he has into buying an asset, is unaware of the total information that is surrounding the decision-making process of that home, of that project. Something which was most evident in this issue of the supernova, super tech twin towers. The people are not aware or not being made aware consciously by the system of so information asymmetry. Now that was supposed to be tackled first, because when you are buying something and you're not aware of what is happening, of the money that are putting in the project, then I think that right has to be restored to you. Second was financial indiscipline. Money is paid for a particular project was diverted to magnify or to increase your business in other projects or buying lands, and therefore that ultimately resulted in the project remaining incomplete for a long time, and you are not getting the home in the stipulated time promised by the developer to you. Now, and whenever you had a problem, then you need to get a resolution fast. That was also not available to you. So you had to struggle either to go to a consumer court, which will take you years, or a civil court, which will also take you years, and very complicated. Now, these were the problems that were there in the sector, and therefore something like a RERA was very essential. And therefore, RERA, which came in 2016, was implemented from 1st May 2017, has tried to tackle these issues. To put it in perspective, the 5 issues that the RERA section, 92 sections are talking about is bringing in transparency so that the information asymmetry can be removed. And the transparency in what manner? Transparency is not mere lip service. Transparency should be on online disclosures. So if there is online disclosure for any information, you are not dependent. Like in the Supertech case, that the people, the RW there, kept on going to the developer, kept on going to the Noida authorities to find out, कि भाई हमको बताइए what is happening there. Now, if that information is out in the public domain, then obviously, with proper awareness among us, we should be able to know how to access that public domain and get that information. So, information asymmetry removal through transparency and public disclosure is the first most important aspect of RERA, and which has been achieved in Maharashtra to a large extent. Also in many other states, and I hope with a uniform rollout of this act across the country, other states also, which today are maybe a little lagging, should also catch up. And with digital technology, you should be able to put out information in public domain. Second was financially, indiscipline was there. How to come up with brought in fiscal discipline. The monies that are being paid for a particular project will be in a separate account, and that 70% of that money must be used for the construction and can be only used for the purpose of that project. To a large extent, has also tackled the problem of diversion of money to other funds, to other projects. Accountability, because ultimately a person should be held accountable for his acts of omission and commission. Something which he should not do, he does. Something he should do and he is not doing. On both the counts, he should be held accountable. So accountability is another major principle on which the act is based. However, I would have been happier if this accountability could have been extended to all the stakeholders in the real estate chain. It should not be only confined to maybe the developer or the professionals working with the developer. It should be also extended to others, maybe the financial institution, the landowner, and also the officials, the authorities who are responsible for various approvals. If they are not given in time, they should also be held responsible. So accountability was also there. Would you like questions to be taken in between? Or?
Actually,
yes.
This is the expansion of the accountability.
Sorry?
Can you expand on the accountability? How are they accountable? That's not clear.
No, accountability is basically that you have clarity on what is supposed to be done by you. And if you do not do that, then there is penalty for your non-compliance of that action that you are supposed to do. So there is some mandatory disclosure that you are supposed to do. There is some disclosure that you are supposed to do every quarter, every 3 months you are supposed to update the progress of the project. There are certain fields on which you have to put out information. So those acts which are expected of the developer or maybe also a real estate agent, if he or she does not do that, then there are strict penalties provided in the act, and you are held responsible immediately for that. So that's the accountability. And the same accountability, as I was mentioning, should be there for all other stakeholders also. Because any act of omission or commission of any other stakeholder can affect the project. And the people who will get maximum affected by a project's slow movement or non-completion would be the home buyers and no one else. Maximum affecting them. So, third point was the accountability, fourth was compliance. There's huge importance given to complying with the various provisions of the Act. If you don't comply, then there are penalties prescribed, and penalties have been imposed, and that puts a deterrent on non-compliant behavior. And fifth, and most important, is customer centricity. All the actions that are there are in the interest to safeguard the interest of the home buyer who has put in the total money. So these 5 principles were something that were followed while we tried to bring in and implement the provisions of this Act. And therefore I feel that it did bring about a paradigm shift in the thinking process and in the implementation of this Act. The problem was that the Act was to deal with legacy projects also. And it's a good thing because it said projects of the past which did not get completed, the Act should also try to see how to complete the project. So the basic tenet of this Act was that the Act should attempt to register a project to see that the project should be completed. Not only a new project which will come up after 2017, but even projects which were there maybe of 2007, 8, 9, 10, God knows when. But they still have not got completed. The developer was mandated to bring in that project also as an ongoing project and register the project. With the purpose of that you can be asking for a new timeline and you should be able to complete the project in that timeline. So that legacy project which was brought in has been an area which in this transition period of 5 years also was not able to tackle because the problem of this sector was so large prior to 2016 that even with these provisions of the law, the legacy projects continues to be a pain point. And the pain is maximum felt again by the home buyers who are there associated. Again, to give you the example of something which was brought down, also had people in hundreds in those towers where monies were paid by them in 2006, 7, 8, and then they continued to wait till the High Court in Allahabad said that demolish it, and another 5 years, finally it was demolished. Still, people who had paid money have yet to get the money. Many may have got. But even getting back the money with even 10-12% interest does not suffice for that person who wants to go out today to buy a house, because with that money he will not be able to buy a house today. So ultimately, it is the project in which you were there. If you get that project completed, then I think you have got the real asset in hand. It's not encashing of that asset and putting it into money and giving it to you. So these were the concepts on which this has worked. But then there has been a problem still there. Out of these 14,000 ongoing projects in Maharashtra, I think not more than maybe 7,000-8,000 have got completed till now in these 5 years also. So it leaves us with good 6,000-7,000 projects which may be stressed, which may be 9,000, which are stressed, stalled, and causing innumerable hardships to the people. So that would be an area one will have to work to see how do we tackle that problem. Coming to the fifth point of that, if a person had a problem in the earlier regime, you did not know how do I get it resolved. That was tackled by this quasi-judicial authority created under RERA, which was expected that if you file a complaint, it should be an easy method of filing complaint, again in an online method, maybe an online hearing if it is possible. COVID expedited that, an online hearing process, and also an order which is issued in time so that you get justice. You may not be happy. You are unhappy with something. You have a question?
Yes. We didn't ask it later.
I have a point.
So what is the next time for turnaround time for MahaSeWA? And the second question is
Oh, I have not completed it. So I'm on that. I've just come to that point. So essentially, the issue of grievance redressal, which should be again time is of essence there. As time is of essence of the project getting completed because the money is stuck there. Similarly, if there is a problem I have faced and I have not been given justice by the developer whom I have paid the money, then I should be able to get a decision in time. Now, the Act stipulates that within 2 months it should be done. If it is not done, then the order issued should actually specify as to why this delay has happened. There has been a delay there. To start with, of course, a lot of effort went in to see how to expedite that process. Effort was also made to bring in alternate dispute resolution mechanism, what we call DDR, called the conciliation, which was very successful again in Maharashtra, because 8 out of 10 cases that went to a conciliation was getting resolved in a proper manner. But in the quasi-judicial also, with hearings taking place in the initial years, later on COVID added to the problem of the people, which also led to more complaints being filed. So today, as I speak here, maybe around 16,000-17,000 complaints would have been filed in Maharashtra, which is less than, of course, in UP, which has about 40,000. And out of 17,000-18,000 complaints, around 10,000-11,000 complaints have been disposed of, which leaves a staggering 6,000-7,000, which are still pending, which is again not a sustainable sort of a thing, and should not make anyone comfortable to live with. Because that means that any new complaint which will get filed today will not get listed in 2 months. It's as simple as that. Because the person who has to hear those complaints will also be limited, with also vacancies arising, vacancies not getting filled in time maybe. So therefore, effort I think the present Maharashtra is also doing is to see whether any complaint that arises can quickly, one see whether there is a possibility of a conciliation mechanism there, which if it fails, then it should be actually taken up in the quasi-judicial way, which I think is the correct method to take it forward. Because essentially, if by making the two disputing sides who have points of difference to sit across and understand with facilitation from maybe a conciliator or a conciliation bench, which comprises both a developer's representative and a consumer's representative. If that happens, it's good. I am told still, with this cases, all cases being asked to go through first conciliation still results in 60% getting resolved in a conciliatory manner, which again is a good figure. Now coming to these 10,000-11,000 complaints which were heard and decided, the point that you were raising, the question came up of non-compliance or non-execution of some of these orders which have been passed. One is, of course, the percentage of these 11,000 cases decided by RERA, which ultimately ended up in an appellate tribunal, was I think 10%. Okay, so even in these 11,000 cases to be disposed of, to my understanding at that point of time, around 50% of the cases where the two sides decided that yes, let's have a consent order by which we will get this. So obviously those 50% cases will not be taken to the further higher court. Among the other 50% also, there have been instances of both. One, cases where one party is unhappy and has taken it to the appellate tribunal. Two, where neither the person has taken it to the appellate tribunal nor he has complied with the order, which is quite serious. Now that's another area to work on to see how execution of orders, because order is a quasi-judicial order, one should not allow that order to just remain and not getting executed also. So it's another area that as we speak, as to what are the hits and misses of the 5 years of RERA, I would feel that looking forward, we'll have to work areas as to see how do we resolve this of bringing down pendency, trying to prevail upon disputing parties to see that whether alternate dispute resolution mechanism like conciliation should be first attempted or not, how do we strengthen that, and two, where cases ultimately cannot get resolved in a conciliation, it comes to a quasi-judicial forum, how that decision making can be even faster to adhere to the timeline laid down in the Act, and once an order is passed, how do we ensure that it gets implemented fast. These are certainly the areas, because if we say and go back to what were the problems in the sector and what those problems have to be resolved through the new Act, this was certainly a problem then and should not remain as a new problem that should emerge out of implementation of RERA, I feel. So therefore, that will be another area that we have to look into. Now, coming to what all things I feel the implementation of the Act should bring in, it has already brought in transparency, it should bring in further transparency. And that is a mindset that a developer community has to get into. He is usually very happy in keeping information to himself. So how can he be brought into that level where he feels that the more I disclose, the more information I put out in the public domain, the better it is for me. Now that sort of mindset will have to be brought into the developer community. I don't know how it will happen, but if that happens, it is good for the developer community also, I feel. Because the more transparent you are, the better it is for you, and at a later date, you will not face a problem that was faced in the recent Supreme Court order. The developer community and the consumer should look to see how do we build trust between the two communities. Because the consumer is one who is making maybe a one-time buy. It's a buy which in the whole lifetime, putting all his money and resources together, he is buying. If he is buying from a person who he doesn't trust, is something which is not a sustainable situation. And therefore, I felt that conciliation forum is certainly an area which tries to build trust. And trust building is the second T that should certainly be attempted by each one of us. Third T, of course, is, which was the pain of the past, of timely completion of a project. So if a time stipulation is given, well, taking a booking from a buyer and said that I will complete it in 3 years, 4 years time, it should be 4 years. If he feels that there are problems, he should say 5 years. But he should not say 2 years in order to attract the consumer and then end up in doing it in 5 years. That's something which used to happen in the past, to a large extent has been controlled. Today you will find developers also saying, at the peril of losing a consumer, because he puts out a date that I will complete a project in 7 years, he might not get a buyer. So he will have to make a business decision where he puts out a timeline which is reasonable enough, where he can complete it, and which also can attract a person, because all projects are out in the public domain. So a person today can make an informed choice. He is not dependent on someone who will come and say, oh, why don't you go and buy this house? This is a very good developer. He can actually access the website and get all the information there. More professionalism will now be required among developers, because they will have to now see that they have to become digitally proficient. And each of the professionals, the chartered accountants, the engineers, the architects who are working with the developer, each one of them, because all information is to be put out in the public domain, and the public is also getting more aware. So digital expediency and proficiency is something that we have to be brought in. A third stakeholder in the act is called the real estate agent. I had a feeling that the agent also should have a minimum threshold limit to actually become registered as an agent, because he is a most important cutting edge level who goes out to meet the buyer, to tell them about the good things about a project. And I feel that there should be some sort of a competency test that should be done. Maharashtra had started the exercise, but it has still not ended up in doing. Customer centricity would have to be putting the customer first, involving the customer in your decision making. Is another mindset change that will be required among developers. They will have to actually go out, and from the day they get the first customer, they will have to be treated not as a home buyer but as a home owner. A home owner is that he is becoming an equity partner in that project till the project gets completed. If you treat that person as a partner in the project, then your whole thinking process will change, and then you will say that all my information sharing has to happen with that person. Now, adopting alternate dispute resolution, as I already mentioned, that one will have to take it there, not only to bring down the pendency of grievances, but also to say that this is going to rebuild the trust deficit that has been creeping in. I'll end with these 2 points. The present functioning of RERAs across the country, or their efficacy, is being judged by RERA has registered how many projects, RERA has registered how many agents, RERA has disposed of how many complaints. I would feel that 2 more parameters must be added to the efficacy of a RERA. The first, I will take you back to, if RERA is intended to register project with the purpose to see that the project should get completed, then it should also monitor and should put out in public domain how many projects registered today have crossed the stipulated timeline, have still not been completed. Now that is a data that has to be monitored, and one has to see as to how do we bring down that number, so that more and more projects get completed in time. 1. And 2, as I mentioned, that grievance redressal has to be timely. And if suppose that's not happening, so merely saying that we have disposed of say 1 lakh cases in the country does not suffice. If that 1 lakh is out of 2 lakh cases filed, then that's not a happy situation. So I think what should be monitored also is how many cases are pending and for how long. So I think I will stop here. I have given you the basic broad parameters of this, and I would love to have questions from you. Yes, please. Condition rate meaning?
Execution.
Penalties are imposed, or he stated that you return this money and this much money along with interest and that. The non-execution of the orders out of these 11,000 cases would be what about? It will be 500. Why will you be happy with an imprisonment? Why are you trying to go back to a system where you feel very happy that the poor person is put in? Let me complete. I have understood your problem. I'm trying to say, please get out of this mindset. As I'm telling you, developer should get out of a mindset, you should also get out of this mindset. Don't be happy that he's imprisoned. If DK Kulkarni is imprisoned, do you imagine that 10,000 buyers are out on the street? Because by putting that person behind the bar, the 10,000 homes could not get completed. So the idea is to see how do I penalize him, bring him back on track, make him function, so that you get your home. I would do it that. RERA, at least the MahaRERA portal, is totally anonymous. In fact, a developer who makes an application for getting a registration, he can track his application to see how his application is moving in level 1, level 2, level 3. He doesn't require to know as to where or who is actually assessing my application, and sitting at home he gets a digitally signed certificate. So I think there cannot be any more user-friendly registration process than is followed in Maharashtra.
Engineering also the same way should be internal process and automatic without any human touch. To know all the aspects which you suggested.
No, software actually brings out all these data that I am mentioning to you is coming out of that only. That software itself throws up as to how many developers have not updated quarterly reports. The RERA also has created what is called as a self-regulatory organization. Mr. Anand Gupta is also a member of that, which means the developers' bodies, which are either under a CREDAI or a NAREDCO or a builders association or any other association, is also pointed out that these are your members who don't seem to be complying with the provisions. So you please tell them before we impose penalty on them.
That rules have to be accordingly described. We'll take care of these issues, not install and all this for the follow-up.
That's right. They are prescribed, they are already there, but ultimately you see no system can be better than the person who runs it. Let's not forget that. Even if suppose you are saying that the system is running on its own, but I don't think there is any system that runs on its own. There is someone. He, to a large extent, his discretion or dependence on him to give out the information can be taken away through software. But ultimately, the system will have to be run. Let's accept that.
Systemic failures we have.
No, did you not face the same income tax trial in the portal when Infosys brought in this new thing? Lot of people face this problem of there were glitches. Now the glitches although has to be sorted out by a person who will have to set right the system. Similarly here also in Maharashtra, there would be glitches. Like in fact after 5 years, the new real estate agents had to come back to get their renewal. The renewal was not happening initially, but then those glitches were removed. So what I am saying is that ultimately the system has to be very good. The person who is running the system, at least at the helm of the affairs, also has to be aware as to what is going wrong and should take corrective measures immediately. I think that's the solution.
So,
Yeah, you can have the question.
so just to expand on your suggestion for increasing the net for the stakeholders, would you see that the BMC and their engineers and all also being accountable?
That's right.
Because what is happening is
That's
many
right.
times all bidders are also dependent on
That's
you
right.
know getting support from them. And many a times if things don't work as per the engineer's requirement, files go into cold storage.
Yeah.
So how does that, how do you gap that?
No, exactly, that's the point I mentioned. That this is an act which has now stayed with us for 5 years. It's time that we should go back to some of the provisions of the act to see how we strengthen it further. And this section 37 of the act, which talks about that the authority, the real estate authority, can only issue directions to a developer or an agent or maybe a home buyer. But then, if there are other stakeholders, most importantly, the one whose approvals or whose decision or whose acts of omission and commission can actually mark the project is someone who has to be made accountable. And therefore, I feel that that accountability has to be brought into the system, wherein the person who does not take his decision in time or is taking wrong decision should also be held accountable. So I think that will be an amendment that will be required in the act. And I personally feel that the amendment is necessary. The second thing I was strongly feeling, I was just discussing before this meeting, is that when a project, everything is going fine, the developer, you are getting the money from the buyers, buyers are also buying in the project, money is coming in, there is liquidity, project is completed, good, hunky-dory. But then every time it doesn't happen so. Even in a new regime, for a new project, it might so happen that there are no buyers coming, or some project decision gets stuck, I go to the cold stage as you mentioned, it can happen. If such a situation happens and the decision does not get taken in time and the project becomes stressed and stalled, how do you put it back on track? Now, the provision in the Act states that the putting back on track is that the authority will talk to the Association of Home Buyers and see how the balance work can be completed. But you cannot only take a decision to complete the balance work by keeping the other stakeholders out. Other stakeholders meaning that there will be a landowner who might have stakes in the project. There will certainly be a financial institution, a bank, or any other investor who is putting money and who has also charged on the unsold flats. So I feel that is another very important aspect of the Act which has been missed out. You see, when the IBC, Insolvency Code, was brought in, it had talked about that any financial creditor has a problem, he will raise the matter in NCLT. But then soon they realized that for the real estate sector, the home buyer who has put in money, maybe 50-60% of the money the home buyer has given, and the financial institution maybe have given only 20-30%. But still, the IBC was giving a preference only to the financial institution, but they amended that. And they brought the home buyers also at par with the financial creditor. Similarly, I think, here in the RERA Act, you have to bring in that financial institution who has also the first charge on the project to be also a part of the association of allottees. Maybe a deemed allottee, because that flat unsold is mortgaged to him and he has put in money there. So he will also have to, if he has to put in more money, he should put in more money to see that the project is complete. So these are some of these things which I feel also discussion should take place and should strengthen the Act further. And the Act will become more successful if we are able to create more awareness among the consumer at large. Even today, maybe we have been able to create an awareness for the home buyer that if you are buying a home, please ensure that it's a RERA registered project. Merely being a RERA registered project and knowledge of the RERA number is not sufficient. He will also have to be told that please access the website, web portal, see the web page, see the credential of the developer, see in the past how he has done, see the litigations that are there in the project, see the number of complaints that have been filed. All this information is there. But unfortunately, I think not much effort has gone in to make aware the public at large that this is the way you should go. There is more awareness about the income tax portal, but less awareness about data.
So, any mechanism to check the authenticity of the
mechanism is that if you put it out in the public domain, then it is expected that the people who are the affected person. No, you have to be aware. Don't expect that the RERA authority before actually putting out the information to do a checking. If you are doing that, you are entering into creating another monster of a building proposal department. Mark my words. If before registering the project you give so much of power, then I will not register a project because I first check all the information. What is happening may be few RERAs. Then in that case you are entering. The thing is to create more awareness, ensuring that whatever is mandated must be put out in the proper format. I am not saying that that should not be checked. The legal information, the litigation information, all the information has to be there. What is the meaning of verification? You verify that it's a legal document. It's a legal title document. That is certainly you see. It's not something else that is done. If you are putting out his PAN number, if you are putting out all the other details, you do check. If you are putting out the commencement certificate, then you see that it is a commencement certificate. But you don't do that. I will first go to the PMC to check whether this commencement certificate has been issued by you or not. That's the point I am making. That will be a too dangerous attack. Tagging should be done. Basically, digitally, the organization should talk to each other in such a manner that immediately you should be able to do that. And that's possible. That's what is digital. That's right. That's right. So essentially, it has to be where the information is just put a click, and then you know that yes, this is something, it's registered there, or it is there in the land records, or it is there in the BMC portal. That's how it should be.
Yeah, I think we will have further questions with the participants.
Thank you, sir.
Thank you, sir. You have enlightened us as to the main aspects of the RERA. Now, before RERA could come in, or even today, there is an alternative remedy to the consumers. That is Consumer Protection Act 2019. Earlier it was 1986. So we have with us Advocate Mithil Sampan. I request Mithil, from there only, you can just enlighten us. If I have to compare RERA with consumer code, because even now there are a lot of confusion among the consumers, saying that RERA is still promoting the developers. They are tilted towards the promoters, the developers, whereas Consumer Protection Act is for the purpose of consumers. So one has to explore and go to the consumer code rather than coming to the RERA. So how you look at it, and what is your view on that?
One thing we have to keep in mind, my dear friends, is that when RERA Act came, it was a new act. When an act, as a lawyer, what we have seen is that when a new law is passed, there is not much precedent or there is not much ground to proceed when the act is new. With time and with experience, judgments will be built up, the operating procedure will be built up. And coming directly to the question now, when RERA was new, there was, I would not say a little confusion, but there was a little that even the authorities, for the first time, the authorities were put in this position of a judicial person for the purpose of real estate for the first time. There was a learning curve. I will use it in the past tense. There was a learning curve of how the government authorities should deal with the problems, not just in litigation, but to amend and update the law. Wherever there are loopholes or grey areas in the law, there was a learning curve and the authority needed experience of how to fix the problems by way of amendments and by way of judgments. As of today, I am very proud and very happy to say that it does not make much of a difference, it is not much of a confusion. Either of the places you go to, you will get your justice. Whether you go to consumer court or whether you come to RERA, after so many years of implementation of RERA, the learned authorities have become more experienced. I am sure that the learned authorities, from one chairperson to another chairperson, I have no doubt in my mind that they share their valuable and invaluable experience from their successor to successor. And as of today, the operating procedure is so much experienced and efficient that the procedures are very well set. Common man is getting the justice. One more thing I would like to say is, when RERA was new, in the first year of RERA, and when judgments were being passed by the authority and by the tribunal, RERA authorities were borrowing the justice which was given by the consumer courts. Consumer Protection Act is a very old act. From 1986, there have been judgments which go into the jurisprudence and go into the legalities of how to protect the consumer and purchaser. One very good thing what RERA has done, and the tribunal as well as the authority in the judgments, what they have done is, they have recognized that a flat purchaser, he is literally the consumer of the service and the product. So the good thing they have done is they have put the flat buyer in the same capacity, and they have used the same legal principles of the Consumer Protection Act. If something is wrong under the Consumer Protection Act, if it is declared under Consumer Act that builder is wrong by doing this, those same principles have been adapted and adopted by the RERA, and that is how the jurisprudence and the judgments and the procedure of RERA has been slowly but steadily been building up and becoming strong. It is a very good thing that RERA is using Consumer Act provisions and judgments to strengthen the RERA. So in short, just to conclude that answer, sir, as of today, it does not make much of a difference. Even if you go in RERA, almost as a matter of right, you can say that under the Consumer Act, so and so protections are given, and let the RERA also adapt and adopt the protections which are being given to the purchaser.
Advocate Suleiman Bimani, who has been very active as far as certain activism is concerned, whether it is a RTI, right to information, or bringing the fast justice, and of course taking criminal proceedings against the errant promoters. Now, Advocate Bimani, just tell us as to how you look at MOFA, Maharashtra Ownership Land Act, which was there, where people could have been put behind the bar. Of course, RERA also has a provision to put
promoter behind the bar, but this is at the tribunal level. Or maybe even after giving the order, if the order is not implemented, then there is a criminal proceedings available. So, to what extent RERA has been successful in bringing that transparency and the information which is sought by the consumers, whether they are still required to go to the RTI and get the information?
Thank you, Ramesh Prabhu, and all the dignitaries sitting on the dais, and special thanks to Gautam Chatterjee. He is not famous only in Maharashtra, but he is famous in Andhra Pradesh also. Because in one of the matter I had worked for my friend there in Andhra Pradesh, the chairman, when he came to know that I have come from all the way from Mumbai, he had a one-to-one discussion with me, and he had a very high regards and very high appreciation for Gautam Chatterjee. Now I will tell you what is the difference between RERA and MahaSeWA. In RERA from 2017 till date, only 500 complaints have been filed. And I was the second one to get the order in its 5 years. So you can just imagine how fast we are. Although we have stagnant cases of 6,000 cases to be heard, we have registered almost more than 18,500 complaints. They don't have an online hearing system, even in the COVID, but MahaSeWA had that, so many cases were being heard. Now coming back to MoFA. Now in MoFA also there was a provision that if the bidder fails to complete the project in the stipulated time, right? So he can extend the date for further 3 months, that is Section 8, subsection A of MoFA. And even then, in that 3 months, if he was not able to complete, he can get further 3-month extension, that is Section 8, subsection B of MoFA. But I'll tell you, we were not able to pursue that MoFA also because of our attitude. Because there was something wrong with us, with the common man and with the home buyers, because we were very greedy. Because at that time, MoFA was there. If you book a flat, say for 5,000 rupees, after 3 months flat, price of that flat per square feet was appreciated from 5,000 to 5,200 and 5,400 rupees. So we were very greedy. So without seeing any documents, without going into any details whether they have an approval plan or not, what is written in the agreement, we just used to sign. Now who is to be blamed? The consumer, right? Now in MoFA, when the MoFA was there just before RERA, you pay the money. In MoFA there was a provision that you have to pay 20% of the amount and then get the document registered. Even paying 50%, the bidder was not interested in registering the agreement. Then one fine day he will call you that these are the so many amount for the stamp duty and this is the registration charge. Please transfer that amount. And then he will call you directly to the stamp sub-registrar office. You sit there, give a post and sign it. You don't know what is there in the agreement. In one of the cases where I was representing the home buyer, in that agreement there was no possession date. But thanks to NCDRC and Supreme Court judgments where it says wherein you have taken more than 20% of the amount, then 3 years is a reasonable time to complete a building. That came to our hand. But now, if you go to the NCDM website, it is so user friendly. You type your ward, which ward it is, K ward, HS ward, and what are the proposals are there submitted in the MCGM. You can see the IOD, you can see the CC, and you can see the flow chart. Now suppose the builder has put up a proposal for commencement. It goes to Ramesh Prabhu's table. When he approves that it is approved on 5th September at 4 p.m., 44 minutes and 15 seconds, that also will come. And then that file is going to Mr. Chatterjee. Now, he cannot keep the file more than 7 days. He has to either approve it or reject it. So that all the transparency is there, which is available on the MCGM website. And whatever on the RERA website the builder has declared that I got the CC or I got the IOD, that you can cross-check and cross-verify. It is at the click of the mouse. I tell you, our user friendly. Only thing is you cannot file RTI online in MCDM, you have to file it physically. But there is no need, if you click the MCDM website, go to the citizen charter and whatever information you want to know, it is available. Now with the Google, you type any XYZ builder, you will get all the reviews of that builder, how many complaints have been registered in MahaRERA, that also you can go to the MahaRERA website. And now the biggest challenge, if you permit, I can talk about the small projects. Yeah. The biggest challenge which MahaRERA and all the home buyers are facing is about the stall projects. Now, initially I was also of the mindset that the builder has done wrong, so he should be punished, he should be sent behind the bars. Now, let's suppose we go to the police station, we register the FIR against him, and he is behind the bars. Now, what happens to your project? Who is going to complete it? In one of the arguments in RERA, I had placed in the press that he should be penalized. The judicial officer, the presiding member asked me, are you interested, Pamela? No. If he is penalized, the money is going to the RERA. Instead of letting him save the money and complete the project. So our intention is to get the final product. Now, how to go with the stall projects? Now, if the project is stalled, say from 2011, 2012, 2015, the builder is behind bar or he is bankrupt, all the properties, all the assets are being attached by the banks and so any other financial institute. In that case, what is to be done is a very big challenge. Now, in that case, you have to form an association of authorities. Approach RERA under Section 7 if the registration is not revoked. You revoke his registration, then under Section 8 of MahaRERA, the association of LOTs will have the first right of refusal. So what you do is, you have to form an association of LOTs, approach RERA, get the details of all the home buyers who are affected, and get the inventories that how many unsold flats are there. Appoint an architect and see that how much money is to be ascertained to complete this project, and how much money you will get from the unsold inventories. And if there is any charge by any institution, say if he has taken a loan from the bank, so what is that? So you will have to come and sit across and take that project, step into the shoes of builder and complete the project. Otherwise, your flat will be a distant dream. He is not interested because he is not going to make money now. In one of the case, the builder is supposed to receive 50 crores from the home buyers, or say 60 crores from the home buyers, and the same amount is required to complete the project. So for builder it is not a win-win situation, right? And the project registration is also lapsed. So what has to be done in that case? In that case, the association of LOT is to be formed and take it forward and complete the project, because now there is a trust deficiency. You don't trust the builder, and builder is also not able to collect the money because of his reputation. So you have to use Section 8 of MahaRERA, step into the shoes of builder and complete the project. Yes.
Thank you. We have with us CA Sunil Naik, who has, or rather who is working with more than 200 developers and especially concentrating on compliance as part. So Gautam Chatterjee sir said compliance is one of the most important aspects in RERA. So what type of compliances that a developer or a promoter is required to do? And if that is not done, how the allottees will come to know, and how it can be checked and seen that compliance is also done.
Thank you, Professor. And after the lovely lecture by Professor sir, I think all of us are aware what RERA means for all of us. Friends, I am present developers most of the times, so I am on the wrong side of the law most of the times. But the compliance is expected are really about the exact rules of law, what the law intends to achieve, and in case there is a default on the part of the developer, what are the consequences. Once the developer is aware that the consequences may come, and when we show the cases, then the consequences have resulted, like penalty being imposed upon the developer, then they start realizing that yes, this law has come into play, and we have to make sure that compliance are done in time. So the compliance is basically giving all the transferred information to the ROT. The purpose of the law, as sir explained to us, is to create a symmetry of information so that whatever is understood by the allotee is the truth and nothing else but. So the developer is required to give all the information about the project in the correct way and in a manner which can be understood by the allotee. So before the allotee takes a decision to buy a property, the portal will give all the information required about the promoter, about the approvals, about the funding, about the state of the project, the exact status as of today. All this will be given to you on the, so you can look into all those aspects of the project, date of completion, the areas involved, litigations involved. All the information is made available to you on the portal. So a developer is required to give all this information to the authority. RERA is very strict about it. Now, when the project moves for registration from phase 1 to phase 4, each of the days you are required to make the proper compliances, give all the information. Unless all the boxes are ticked properly, we do not get the registration. The process is absolutely simple, provided you are making all the compliances. If you want to tamper the law, do not make the compliance properly, the registration doesn't come your way. So it is smooth for a developer who is doing it in the proper manner. But for somebody else who is not making the compliance, it is a different position. Secondly, the compliance basically look into the progress of the project over a period of time. For example, approvals received by the developer from time to time have to be uploaded on the website. So you as the home buyer come to understand what is the status of the project and what the approvals are concerned. Secondly, about the sold flats and unsold flats. That also data is available to you on the RERA website. Thirdly, about the exact date of completion as proposed by the developer and the status today can be verified. So in case he is giving the date of 31st of December 2022, pending of ground plus 22 structure, and right now he is at the 5th level, anybody can make out that he is going to miss the date. So that is something which you can easily do. And the best part about RERA is that RERA has involved 3 professionals to be a part, other 4 of them, the advocate, chartered accountant, the engineer, and the architect, to be a part of the process to give the information. So these 4 professionals are required to give the correct information to the authority, which means that it is not a developer who gives the information, but it is these 4 professionals who are giving the information for the benefit of the authority, which means that the authority is very sure that it is giving not the developer, but it's 4 professionals who are competent and who are required to follow the law to the T. And in case of a default by a professional, it is able of him also. So you cannot take chances with the project or with the RERA. So from that perspective, it's very clear, compliances are a must and they have to be given and to be delivered in a given time period as well as in a given manner. So no chances can be taken about that.
Okay, thank you very much. We have with us CA.
I have really much more to add.
Yeah, please.
This compliance, that of course he is doing a good job telling his developer clients. You should do compliance and this information should be covered. I would have a question as to who is working towards making people aware that whether the compliance has been done or not, is being seen or not. And that becomes very important. Like if he has given a timeline and complete in 2 years, every 3 months, how is the progress going? He may have told the developer you must upload the progress, whether the peak was there, this was there or not. Is someone making people aware as to how they should see the information that is put out there? I have a feeling that's an area, right, so which we have to work.
It's very important question, sir. This is a very important question. I agree with you because this all big engineer, architect, they all do. They say all these things. They come here and they say this thing. But what about the people who doesn't know anything? They are ignorant. They should teach that. Then only the awareness will be there. But just that is a very important question. That which I fully agree with you. We should put that more seminar for that also. How to know the people. Because consider पता नहीं तो करेगा क्या वो तो फंसेगा ही कितना भी कर लो.
Yes, valid one. I think in the initial period that was little difficult, but yes, now we have 5 So now we should be in a position to, get that implemented. Maybe we will definitely do a representation. Now we have with us CA Ashwin Shah, who is the president of RERA Practitioners Welfare Association. In addition to that, he is also an insolvency professional. Now, because he is an insolvency professional, he is also a president of RERA Practitioners Welfare Association and practicing in RERA as well as NCLT. I have a question to you. The way I have put a question, Consumer Code and RERA. Now we have IBC, Insolvency and Bankruptcy Code, and also we have RERA. And a consumer, as per the Supreme Court judgment, is a concurrent provision. So, which you think is advisable for a consumer to proceed? As far as when there is a stalled project, is it advisable for him to go to NCLT or come to RERA when there is a project which is getting stalled? Because more than 100 awardees or 10% of the awardees are required to proceed or file a petition before the NCLT or invoke IBC. And that too when promoter is becoming delinquent, that's where we look at the NCLT. So given a stalled project, we have RERA under section 708 as Bhimani has rightly pointed out, which we can invoke and go to RERA and get the project completed through an associate awardee. Or an associate awardee can go to NCLT and then get the things done. So which you think is the best option given a different circumstance?
Now, before we answer this question, the main objective of RERA is not to give refund or interest for delay. The main objective is to ensure that the home buyers get their dream house. That is the main objective. In fact, there should not be any litigation. This should be the main objective of RERA. And if we look at some of the statistics, see, as of today in Maharashtra, we have around 36,000 projects were registered. Out of that, 10,000 are completed, right? And there are some projects which were ongoing on 1st May 2017. So nearly half of that is 18,000 projects were in the category of ongoing project. Balance 18 were new project. Now the problem is not with the new project, because when a promoter after RERA coming into force, if he register a new project, he has in his back of mind, he has all the mindset, I will complete the project and accordingly I will give the time. Now all the problems were associated with the ongoing project. So those 18,000 projects, out of that around 6,000 to 7,000 or 8,000 completed, they got the occupancy certificate, they have uploaded form number 4 which is issued by architect. Now there are some projects where OC could not be obtained because of some technical reason. The project is completed, say 90%, 95%. But for some technical reasons, some dispute or so, landowner dispute and so, the OC cannot be obtained. So the maximum problem, maximum complaint also flowing were from the ongoing project, not from the new project. If we look at the total 16,000 complaint, hardly I can say 1,000 complaint will belong to new project category. 90. So all the complaints were because the developers were again taken by surprise. They have to be governed by RERA. So they have made some provision. We have made some data analysis wherein the project was launched in 2010 and the revised timeline was given in 2035. And today also that project is at excavation stage. Right? So here these are the issues pre-RERA, not the post-RERA. So here again the RERA authority now the last project. As of today, what is last project is that timeline is over. What one chance was given to the developer. So even as of today, nearly 4,500 projects in Maharashtra are lapsed projects. But that does not mean these are the only number. Apart from that, even though the timeline is there, say for example, I have given an example 2035, but that project is also stagnant. It is stalled. So this figure could be around in the range of 8,000 projects, I would say. Now, what will happen to this 8,000 projects? Now there are many ways in which this project can be converted into dream reality. And many forums are available where allottee can go. Because now Supreme Court is very, very clear. The choice of forum is with the allottee. It cannot be thrust upon me, you have to go to RERA only, or you have to go to consumer forum, or you have to go to IBC, or you can go to arbitration and so on. Now IBC again, the main objective is not to kill the company, is to maximize the asset of the company or continue the company as a doing business. Again, the objective of IBC is very clear. Supreme Court time and again has said that IBC should not be used as a recovery tool, but it should be used as a maximization of the value. And there are some judgment of the Supreme Court wherein there was a reverse IBC, reverse CIR, wherein the Association of Authority have been given a chance to carve out the project. Suppose, say for example, in a corporate, there are 10 projects and 3 projects are stalled, 7 are going very well. Now, because of these 3 projects, the financial creditor, that is secured creditor, banker have went for IBC. They have filed the application under IBC. Now, because of that single application, the entire company goes into liquidation. Now, what will happen to those 7 projects which are going very well? Means it has all the chances, fair chances of getting completed. So there again, 1 minute. So there again, Supreme Court has said that reverse CIRP is possible. Again, there are development going on in time to come. How that can happen? So whether this 7th project can be carved out from this liquidation or not? Because once the liquidation is there, then entire company goes into the hand of the insolvency professional, and then all the assets of the company would make the liability. So now the question is whether authority. Now authority was neither was the operational creditor nor was a financial creditor prior to that amendment what sir has said. But now there is an amendment in IBC code which says that authority is a financial creditor. If his agreement is registered, then he is a secured financial creditor. If his agreement is not registered, then he is an unsecured financial creditor. Now the limit under IBC is 1 crore post-COVID. Prior to COVID, it was 1 lakh. The trigger amount was, if there is a default of 1 lakh prior to COVID, then one can drag the company to IBC. But now that limit has been raised to 1 crore. So it may happen that allotee who has paid say more than 1 crore, a single allotee can drag the company into IBC. So to prevent that, the act is now very clear. It says the 10% of the allotee of that project or 100 in numbers, whichever is higher, should go and they can trigger the IBC. Now, IBC is also not a welcome step. The ultimate step should be how a stall project can be converted into train reality. So here there are other stakeholders. Say for example, secured creditor is there, then planning authority is there. Because in Haryana there was a development in one of these stall projects. The planning authority also gave various concessions to the project. There were order passed by the RERA authority Haryana not to call for recovery on account of all the approval fees till the project gets complete. So that much relief was given. Even sometime the more FSI can also be granted just to ensure that project gets completed. So these are all development. It is bound to happen in time to come because in Maharashtra also we had a panel discussion in the month of June at KC College wherein we have discussed all these issues, how to complete a small project, how to convert it into dream reality. So again, the role of secured creditor is also most important. The banker who has created a charge, whether he should be treated as an equity holder, he should be treated as a promoter or not, that is again a fundamental question. Now there are issues of small projects so far as the redevelopment is concerned. In Mumbai city, we have maximum cases of redevelopment where there is a society appoints a developer and after some year, society terminates the agreement of the developer for various default. And then the new purchaser, where they will go? Because today the position of law in Vaidai Akas Bombay High Court is very clear. If the new purchaser does not have any relief against the society, they have to go to the developer. So this is the position of law as of today. But now after RERA coming into picture, whether that position can get changed, because we have section 15, which is very important. Wherever a new developer is coming, so he has to take all the rights and obligations of the project from the old developer. So these are all development. Now many judicial pronouncements we have reached up to Supreme Court also. RERA remanded matter again to the authority for reconsideration. So today all these issues are there in time to come. But the main objective of any central government or Supreme Court is also that what is the objective of RERA is to convert the under construction property into a dream house. Under MoFA there was only one relief available and that was exit. But in the RERA we have two relief. One is exit and second is non-exit. And in non-exit you can claim interest for delay. Again to my mind there should be some amendment on this non-exit, sir. Because see, ultimately what was the intention of home buyer was to go for a home and not to do a speculation for interest. Now what is the loss caused to the home buyer is the loss of rental opportunity or loss of rental what is paid, which could be hardly 3%. Today if I look at any rental cost, if suppose 2 crore home is there, the rent cost is 3% per annum. That is around 6 to 7 lakh. But again, this provision is also killing the developer because he has to have the additional financial burden of 9% per annum, which again comes in the way of completion of the
Thank you, Ashwin. Now let us get to Gautam Chatterjee, sir. Sir, Supreme Court has held that insolvency and bankruptcy code is overriding the RERA. And as you are rightly pointed out, there is a conflicting interest. One is the financial institution who have given for the initiation of the project or project loan, they have mortgaged the project, they are looking for their institutional fund, which of course they have taken from the various consumers in the form of deposit. Now there is a consumer who has also invested crores of rupees collectively in a project. So naturally consumers will come to RERA and the institutions are going to NCLT. Now in this situation, what advice, now that you are not in RERA, so you can certainly give us an advice, what advice you will give to the consumers and what path they should adopt?
Very good. I feel, Rameshji, that whether it is the consumer or the developer or the financial institution, because RERA is my baby, I would feel that the best solution to all the three stakeholders is RERA. Why? Because I am saying is, again, not to offend our excellency professional here, because
he has got both the legs.
Ultimately, all these three should be happiest when the project gets completed.
That's right.
Because even that financial institution who has given money for the building to come up and has a first charge on the unsold flats, he will also get maximum return when that unfinished project becomes a finished project. Even 80%, 90% complete project, if it goes in liquidation, if you make a distress sale of that, you will not fetch 90%, you will fetch with a haircut maybe 40%. Whereas if some money is put in to complete that 10%, that last mile connectivity, everyone, the developer gets benefit, the unsold flat wala, the first mortgage, financial issue gets benefit, and certainly the home buyer gets his home. So therefore, I feel that whenever something gets stuck or stalled, then you will have to embolden RERA and give the first opportunity to RERA. I am not putting in any conflict between RERA and IBC, but I have always held that RERA is a specific act for the real estate sector. IBC is an act that deals with all sectors. So if you have a tussle between the two, you should give a preference to an act which is created specifically for the real estate sector. Now, I am not saying that you will debar the other one. I am only saying this, again speaking from experience. I was dealing with the case of HDI.
Yes.
And we were close towards working as to how to bring in Section 8 to see that this project gets completed. One of the projects, not all, there were distressing many other projects.
That's correct.
What happened was, someone, maybe was propped up also to go to NCLT, moratorium applied because it was admitted, and then all the efforts that we had put in to bring back a project in time, and all the buyers were also interested, got stalled. And they were very agitated. How is it that you have not allowed us to take this process forward? So, I feel that at least a reasonable 6 months' time must be given. If suppose home buyers have already approached RERA, or maybe question after doing amendment in the RERA Act, in section 8, you bring him also as an important stakeholder. If he also, instead of going to SARFACI, instead of going into NCLT, comes to RERA, it's a question of faith. If RERA is immediately taking up the process, then I think those stakeholders should be given a 6 months time and a time to see, because RERA is insolvency professional, come NCLT, rolled into one. It will also do the insolvency professional job to work out a blueprint to see how the project gets completed, but you will have to take the other financial institution also. So it will require an amendment and it should give a first preference to RERA to see whether in 6 months you are able to bring it back on track. If that happens, and if it doesn't happen, then only you go to other liquidation or anything.
So, just to add, even in IBC, once the case is admitted, now Supreme Court has made it very clear. If there is a chance of revival of company, and if the one of the traders who has filed the application, he can withdraw the application. That is also permitted, provided there is some settlement. Settlement may not necessarily be paying the amount today. It can happen in future also through negotiation. And now this withdrawal can happen even before constitution of committee of creditor, after constitution of committee creditor, even after submission of resolution plan also, the withdrawal can happen. So all the doors are open in Supreme Court. So that is the only court where
the major problem is that in the NCLT IBC, you are treating the company and all the projects of the company you are bringing under that fold of moratorium and saying that no, we will now see how to resolve all these things. But there are 7 projects, as you said, that could have been solved. Now, on the contrary, under RERA treats every project as an individual unit. It also says that the money from one project should not be given to other projects. Meaning what? That the project is the individual unit. I think the same thing should apply to also IBC. You cannot put a moratorium on the company which stalls even the other projects which otherwise would have completed.
Yeah, so ideally what sir is saying that wherever the secured creditor has filed an application under IBC for a particular 3 project, whereas the default is for 3, so that should apply. So these are the things which will evolve, which will come through a judicial pronouncement sooner or later.
Yeah, I think to clarify what is moratorium limit.
See, moratorium, once the application is admitted, on the day on which it is admitted, it is called insolvency commencement day. So that is the starting point of the moratorium. Now that under section 14, the company, all the suits which are filed or all the cases which are filed by authority in the RERA, the proceeding will come to halt till the moratorium ends. But the moratorium will end only upon the completion of CRP, either by resolution plan or either sending the company into a liquidation. So till such time moratorium is there, so no suit, no recovery, even income tax department, GST department, no government department can attach any property or recover the money. However, the supply of essential item has to continue. For example, electricity, water, these are the essential items. That cannot be halted even though there are default of payment. So that has to be continued because IBC again says that we don't want to kill the company. We want to continue the company as a going concern, maximize the value, settle the claim, and continue the company as a going concern.
So that is what Gautam Chatterjee sir was saying, that they started taking efforts for HDI and then unfortunately moratorium came and everything was stayed. So I think that is what sir was saying.
So I think RERA then will have to go approach Supreme Court wherever such thing happen. That we want to interfere and we want to ensure that some of the project can be easily carved out and complete.
Now,
With blueprint and whatever.
okay. Now, before
Suppose the people who are there are also part of that. If they bring it to the notice of the NCLT court or whoever, that means, sir, we had already approached RERA, there is some effort going on. I think it should not be admitted under section 15. That's the point I'm making. At that stage, they should say, okay, that's the, and it has happened in all this. In Mumbai, in CFT, in one matter, I think the people had more faith that the resolution will happen in RERA. So I'm told that they had gone and then proceeded before the NCLT, and the NCLT did not admit and kept a date, I think 3 months later, to see that yes, come back after 3 months to see you, sir. That's the only plea that I'm making. That's how it should be done in every case.
So, now just to conclude what all the 3 panelists have said. First and foremost, who wants the house? The flat buyers. If they want a house,
then they should come united. There should not be conflict among themselves. So how they can come together? By forming an association of authorities. Now that is a onus which has to be taken by the flat owners. What happens with the flat owners? Flat owners also have a conflicting interest. There may be some investors, there are some who are actually looking for, as a receiving of the flat. Yeah, I have definitely come to that. Before that, so the association of authority is the most important thing. Second, once you have association of authority, the second thing has to be approaching RERA under any circumstances. It is not that you should go to NCLT or other forum, you have to come to RERA. Now having come to the RERA and the complaints are pending before RERA, even if there is a NCLT proceedings or proceedings at other places, the same association should intervene there and plead that there is a pending proceedings before the RERA, which is a special authority, and let the authority pass an order. Based on that, we can take it further. I think that is the process that has to be adopted. Then only you will be able to get the flats. And there, some people also want to exit the project. There, the association authority should ensure that they don't exit the project, they join the project, and thereafter, maybe after due course of time, they may exit. So this is the process that needs to be adopted. Now, Gautam Chatterjee sir has asked me to share some of my, stall projects where, of course, more than me, the credit goes to, of course, the chairman of RERA at that time, Gautam Chatterjee sir. The first and foremost is, you can never and ever imagine this could happen. That is of Mehul Choksi's project. Borivali, that is Gitanjali Tattva project. What happened was around 101 allottees had booked the flat. Just to give you a story, in a very short period, 101 allottees booked the flat. 54 flats were, given to a contractor. 155 flats. The contractor was supposed to complete the project and get those 54 flats. Now what happened? Out of 101, 50 to 60 allottees went to NCLT. Sorry, not NCLT, NCRDC. That is Consumer Court, National Consumer Dispute Redressal Commission, Delhi. They were not ready to join the association allotee. Only 8 or 7 allottees came to me and then said, "Sir, what is to be done?" I said, "Form an association allotee." They said, "How can we do? There are 50 or 60 allottees who have got to NCRDC, they are not coming with us." Then I said, "Let us have one meeting with Gautam Chatterjee sir." And there, the leaders who have gone to consumer court, let them also join. So we had first meeting with Gautam Chatterjee sir, said, "Sir, this is the conflicting, please guide us." Of course, none of the chairmen that way proactively guide us. But he said, "Please bring all the allottees together. Even if they are pursuing that, let them pursue, but completing the project, let them come here." We formed an association allottees. They also joined with us, and slowly with 7-8 people, slowly 25, 30, 60, 80 we got, and believe me, all 101 came on the platform. Of course, it was taking time. 6 months into, lot of media work also we had to do, publications we had to do. People came, joined. Then we filed a petition before the RERA. See, ED has annexed the property. BMC 3 crores property tax was outstanding. BMC also had put a attachment notice on the property. No securities, nothing. And Mehul Choksi is out of the country. And when we filed the petition, the first and foremost remark made by member 1, Dr. Vijay Servicing at that time, he said, "Mr. Prabhu, you have come to the wrong forum. Because here you have come, entire country and the world is looking after Mehul Choksi, and you want me to solve this?" I said, "This is not possible. You have to withdraw the petition." Then I said, "Sir, better you discuss with the chairman and come to certain, at least put a ball rolling, keep the hearings happening." Then we requested that contractor
That's you have 54 flats. No doubt it is attached by ED, properties are attached by ED, but still intervene in this petition and say that we will complete the project and we will contribute the money if required. So there was a consent term. We agreed after 6 months, and consent terms were filed before the RERA, and Gautam Chatterjee played a major role in that. And he said, if this can be done, why not? You get it. So it's a consent term. So we got a consent term done. And today, doing this from 60% of the project to 100% project is completed. People got the water connection, people got electric connection, people got mother connection. People are now staying and celebrating their all festivals.
Great, sir. Very good.
Okay. Now, only one small thing is left out. That also we are sure in due course of that OC is still pending, because what MahaSeWA did when it was a commercial, industrial zone, when it was converted into residential zone, they were supposed to construct smaller unit of 20% of the built-up area. They were supposed to do smaller units of 500 square feet, which he did not do. All the flats were 2 bedroom, 3 bedroom, bigger flats, 1,000, 1,200 square foot area. So there, because of one ionic condition, OC has been held up. We had a series of meetings with the Chalsa, we had with the various this one. They said court is the only recourse. You go to High Court, get a relief, and come back to us, because we cannot touch the project where the MahaSeWA is involved. So otherwise, we would have definitely helped you. But anyhow, we are in the process. But sir, today people are staying there. Water connection has been given. Everything is there.
But sir, OC is not there. They are staying anytime. It can be problem.
No. There are more than 20,000 projects in Mumbai alone, where I am a witness. The projects where people are staying. If there is no OC, tell me how electric connection is given, how water connection is given, how Maharashtra connection is given. Everything is there. Fire NOC, everything is there. Everything is fire compliant. Building is everything is right. Building is completed as per the approved plan. At the time of approval, the MCGM made a mistake. It is not the mistake of MahaSeWA. It is a mistake of the MCGM.
Exactly.
Because
yes,
they passed the plan, everything did, and not once, 17 times plans have been amended by MahaSeWA and even by us. Even our amendment has been accepted. But later when we applied for the OC, they said one of the conditions, it has been oversight, remained. Now they are saying we are not going to touch. None of them is ready to touch it. So we have to go to the court. We are
in that context, I think some progress is better than no progress.
That's right.
It is a positive. That way, what Prabhu said is a positive. He always, every time I think he is positive, that's why it is working. Positive is the best, I think. If you are positive, then I think the whole thing gets done.
Can you believe, just to start a project, we had to go to ED. ED said we will not allow you. We asked the ED. The association went and asked, what is the problem with you? You have attached the flat which is not having completed. We are putting in the money. RERA is giving us a permission to complete the project, and we will make it more habitable and you will have more value. So then they said, okay, if you are not going to touch any of our flat and you are going to complete the common areas and completing the project in the 101 flat you want to do because of the RERA order, we will give the permission. Believe me, 6 months, Andheri electricians, they did not give us a connection. They said, it is an ED project. And we said, we have permission, we have this, we have that. Still, Andheri electric company said, we cannot give this supply. You get us an NOC, you want to give an electric connection from ED. We had to go to ED, we had to beg them, produce all the documents. Then they said, okay, you can give the connection to 101 flats, which we are not attached, and to the common area. So 50, of course, we would not have done 54 flats, no electric connection, and inside flats we did nothing. Everything was done outside. Inside when we have to put a door, and inside everything is kacha of those 54 flats. What I am trying to say is that if you, as an association authority, take it forward, things are possible. Believe me, that 60 NCRTC, no hearing took place for so many years, it is still pending. And
even if the order is passed, nothing is going to come out of that. These orders are not going to be executable. Now people have got a house. Second project, yes sir, you can please add.
I just wanted to say that bottom line here is that though for a project, buyers come from different sources, and one buyer does not know the other buyer. But then, since after the building will get completed, all the buyers, either through a cooperative society or otherwise, you will have to come together. The effort here has to be that this so-called association of authorities, majority, I'm saying everybody will not be able to bring on your side, but someone will have to take the lead to say whatever is good for us, we, the majority, 51%, we shall make it up. If you take the lead, then all sorts of these solutions to any problem, I think, can be found.
But sir, how the buyer, or suppose I am, how I will know like 100 buyers have already invested? How do we get the list to form the association of developers?
That is why RERA is here.
So
The names of the persons are not put out there, but then how many flats have been booked and other information is there. You will come to RERA, then RERA will facilitate that process. If you are not able to get to all the buyers, then RERA will call upon the various professionals in the project and bring them together to get you the information, ask the developer to share that information. This is all possible, but the lead has to be taken by you. And even if suppose there are 5 people who say, no, I want to go to NCRT ourselves, or I want my money back, it is a question of trying to tell them also that we will try and hold your hand, maybe if your EMI is due, we try and see how to resolve that. But don't exit the project. Let us see that, let's get the project completed, then you take this decision. I think this effort will have to be made by the association.
awareness only is there, sir. As you said, people of awareness is not there. That's why people are also doing exit because वो डरते हैं. और awareness लेके कि ये काम हो सकता है, जैसे प्रोड्यूसर ने बताया कि फिक्सी का, वो जिनको पता ही नहीं हो रहा है, वो कम लोगों को पता है, वो बहुत अपने पीछे हैं.
Okay, just to take it forward, अभी महारेरा ने एक बहुत अच्छा कदम उठाया. वो कदम कब उठाया? जब MCHA CREDAI, along with the RERA factory workers under the leadership of CA Ashwin Shah, we had a seminar where, of course, Ajay Mehta, the present chairman, member 1, Vijay Sarbir Singh, and all other people were called with the MCHA CREDAI people, along with the practitioners, developers, all were called. The meeting was took place, and there Ajay Mehta declared, yes, for a strong project, now we have got a amicus curiae. That means I have appointed one retired IAS officer, Sanjay Deshmukh, who will now facilitate the bringing the authorities together, bringing the developers together, professionals together. A separate vertical has now been started by RERA. आपको उसका फायदा उठाना है. मैं आपको बताऊं, हमारा अभी एक निर्मल लाइफस्टाइल का प्रोजेक्ट जो रुका हुआ है, उसके ऊपर शास्त्री कॉलेज ने उसको अंडर सरफेस ही दिया हुआ है. देने के बावजूद तो लोग इकट्ठा नहीं आ रहे थे. 2-3 एसोसिएशन है, स्प्रेड डिफरेंट फोरम थी. तो इसके लिए अभी हमें संजय देशमुख साहब के पास रेरा चेयरमैन ने भेजा है, उधर चर्चा हो रही है. So there you get the association authorities detail. They can, he has certain technical people who will visit the site. He will call for the information. All these, resolving the stall project issues are not taken up in a proactive manner. I compliment to RERA for that initiative.
And
Now,
further,
yes.
the Association of Authority now can use these various social media for uniting. They can create a group. Now all the things are available. You can go to Facebook or whatever.
एक थोड़ा सा
You can maximize the details of the other person. And throughout the publicity, you can get the
And sir, just to answer your question, like how will you find out who are the other allottees in the project? As of today, we are living in internet age. You can go to RERA website. If complaints and orders are passed, you contact the advocate. You go to Google, Facebook, LinkedIn. Many people, you will be surprised. You will find 50% of the allottees on Facebook or even on LinkedIn. You will find it. You contact the advocates. They will guide you and put you in touch with the remaining allottees. It is very much. You visit the site. If people have started living there, or you bump into someone over there. If you visit the building physically, you can go and interact with them.
थोड़ा सा एक्टिविज्म करना होगा, सोशल एक्टिविज्म, एंड उससे आ सकता है. यस, आपका सवाल आ सकता है.
Like I was this conciliation process and this alternate dispute management. So is there a recent thing came up with this RERA or is it there before?
Yeah. It's a baby of Gautam Chatterjee, sir. So he will be the best person, and thereafter all the RERA across India have started adopting it. Sir, his question is whether it's a latest development or whether it started.
This mediation or alternate dispute resolution has been talked about in various other methods. Even the Adalat system is also an alternate dispute resolution. Mediation also has been, most of these Supreme Court, High Court judges have been talking about. But with the tendency of cases rising in various courts, there has to be an alternate dispute resolution. When this Act came in 2017, then there was one section, section 32G, which had talked about that also efforts would be made by the authority along with the state government approval to set up such sort of conciliation forum, either through consumer forum or through developer association. But we felt that a better thing would be if we bring the two together, as I mentioned. One of the objectives of the RERA Act also was to bring back the trust and remove the trust deficit, which over the years has gone to maximum. Now, how do you do that? And therefore, we had discussion with this Mumbai Grahan Panchayat, we had discussion with RERA and CHI, and all of them felt that yes, it's a good thing. If suppose in a cheaper method, less costly, if you are able to find a solution, I'll tell you an example. The point Ashwin Sir has mentioned. The section 18 of the Act says that look, if you want to stay put in the project, you can claim interest. Now, then the question was coming that if the project also has to be completed, and the majority of the people say that no, I don't want to exit, I want to be in the project, but also start getting interest right away, then it becomes a problematic thing as to how do the project get completed. Some of such cases which went to conciliation. In the conciliation, the person accepted that yes, I am distressed because I have to pay rent. So what was accepted they are taking as a conciliation. Okay, for the time being you can take this rent. However, your due of interest to 10% is remaining. You will pay that when the project gets completed. Excellent. So the issue was that the liquidity which is required to complete the project, that was enabled. So that's how in conciliation, in Pune it was 9 out of 10 cases where the resolving was happening in this conciliatory manner. In Mumbai also 8 out of 10. And that is how it started. 600, 700 cases have been taken up by conciliation. Now, of course, even these pending cases have been sent to conciliation, and large number of cases are happening.
So how do we approach them?
It's all available. In fact, if you go to RERA website and you have a complaint, as soon as you go that I want to file a complaint, you go online, you set up your name and your user ID and password. As soon as you say I want to file a complaint, it drops with a pop-up saying that would you like to go for conciliation? So MahaRERA is trying to tell you that there is something else available. So as soon as you click that, it takes you to that page which explains the whole thing as to how conciliation works. Conciliation works in this manner. It is voluntary. So when you say that I want to go for conciliation, that request goes to MahaRERA. MahaRERA then puts that link to the person against whom you are filing for relief. And it also asks the SRO to get after the member of that developer. Why don't you tell him to actually sit in conciliation? So he then responds in 7 days, 15 days. As soon as the response comes, yes, I am willing for conciliation, then 20% of the total fee, which is otherwise charged for a complaint, is charged for conciliation. At that stage, when the consent from the other side is received, and then once you give that, you get a number generated. And then the same thing of online complaint follows there. It gets a number, CC, or whatever. And then the MahaRERA conciliation forum allots a bench. In that bench, there is a representative from the developer, there is a representative from the consumer, and they facilitate this process. And it's working very fine. And as you mentioned, drawing from the experience that MahaRERA got, today UP is very successful. Bihar very recently has started. Karnataka is wanting to start that. So I think each one of them are thinking the need for bringing conciliation. And I think that's the way.
Thank you for the question. Also, is there a time limit for that conciliation process or?
It is faster in this. As I
Within 90 days.
As soon as the other person gives his response, then I think immediately, because there are about 30, 35, 40 benches, the number of people who are hearing conciliation is 10 times, 20 times more than what is heard by the member and the chair. So the chances of that getting heard first is much more.
It is within 90 days they have to dispose of. That is the latest notification issued by RERA.
Maximum 3 years.
Yeah.
So, I think one should, my suggestion would be that everyone should first give it a try. Then only you can.
In fact, now Ajay Mehta sir has started a process that on Monday of every week, first Monday of every week. So what he does is he calls for all the complainants, ask them, would you like to go for cancellation? 50% agree and then it goes back to cancellation. And if that is not solved, it comes back to RERA. So instead, Gautam Chatterjee sir said like this, you pay only 1,000 rupees as against 5,000. Go to cancellation. If it fails with the same fees, the RERA will hear. So complaint gets transferred. That is what.
In fact, we have said because we wanted to give a selective conciliation, rather than paying 5,000 and filing a complaint, you go to conciliation. And if conciliation fails, automatically that case will be taken up by RERA and will be heard at 1,000 rupees.
That means you are saving 4,000 rupees. Yeah.
Yes, sir. So the conciliation take away all the other rights of going to higher courts.
If you succeed,
Generally, when you have an arbitration.
yeah, if you succeed in a conciliation, then obviously you are signing a consent term where both the sides agree on certain terms.
So the bench is comprising somebody from the developer, somebody from the. So is there any RERA officer presiding over?
No.
Or it's completely from guys mutually settled?
No, but then that what is brought up is actually sent to the Secretariat of RERA. Because the whole conciliation forum is headed by the Secretary of RERA. So it has an official stamp, it is not left out as an outsourced mechanism. So whatever is arrived at, that has the same standing as an order passed by RERA. So tomorrow, if what is agreed upon there, if it is not complied with, then it can be treated as something which will be taken up under section 63 of the Act of non-compliance.
So in the bench, the majority would prevail, so there is 2-3 people can say, I don't agree or I say.
It's only if both the sides agree, then only there are only two sides, there are no third.
So your question, I will again put it to Gautam Chatterjee sir properly. Sir, his question is precisely in an agreement for sale, if there is a provision that the parties will, in case of dispute, they go for arbitration. Okay. So once that clause comes, now Gautam, you have been rejecting that. If they have come to RERA, RERA is an additional remedy, it's a special act. You have been rejecting the claim of the promoter that they should go to the arbitration. Whereas now Ajay Mehta sir has taken a stand that if there is an arbitration clause, though the RERA is special act, though it is an additional remedy, you first exhaust your arbitration proceedings and then come back to RERA. So all other remedies gets closed. So his question is, if I go for a conciliation, will all other doors get closed?
The question is that if you are going to conciliation means you and the other side, who both in an agreement agreed that whenever there is a point of difference, we go to arbitration. Instead of taking the matter to arbitration, both of you are now agreeing that no, we will try and see in conciliation which is much cheaper, whether I can resolve it or not. So if you have both decided to go in conciliation, then obviously it overrides your arbitration.
And if not?
If not?
If there is no agreement between them?
So then obviously no agreement, then you will file a complaint to RERA. And as I said,
Those options
before you come to RERA, if there is an arbitration, you first go to arbitration.
Yeah, that's what. Now, of course, it's a matter of challenge now. It is in the
I will not agree on that, but
yeah, you have not been agreeing. Companies was not agreeing, and across India, many RERAs have not agreed to that. But Gautam, he says Ajay Mehta has passed an order saying that the RERA does not have the jurisdiction to override the agreement. So, having agreed for one forum already, now you cannot come to RERA.
I would rather have the model form of agreement to say that whenever there is a point of difference, it will be first taken up conciliation. That's what I would do.
Anyhow, these are the. But it will be, of course, settled in the Supreme Court. Supreme Court has already passed an order in one of the matters that in case when there is a conflict, arbitration and RERA will prevail. Of course, in spite of producing that judgment, we have contrary judgment now. Now the matter is with the appellate tribunal. Yeah.
Sir, as you agree with me that 5 years is a long period. And these 5 years, I agree that the RERA has brought a transparency, completion, some compliance. But still, even after 5 years, there is no solid action plan from the RERA that all these 12 projects will get executed by person A or person by B or person C in a time bound. So, what you as a completing such a RERA has been followed by all the RERA. This is the situation I find not only in RERA or Maharashtra, I find throughout the country. Can you suggest some solid plan which will bring this confidence to every consumer, to every financial institution, when you finance it to the real estate developer? Yes, project will definitely get completed, and it will never come in a stall capacity. And if it comes within 6 months, it will be restarting of the road. Today, we are only penalizing by interest, by some say IBC के जाओ, लेकिन nobody is saying how exactly and confidently he is going to get his house, so that one person developer failure should not be a cause for other persons.
Another two things. One is, of course, that we are still dealing with legacy projects, as he also mentioned. So as long as my initial thinking was, in 3 years' time, we should be able to get over this transition and this legacy project. It has taken 5 years, and still we have 8,000, 9,000 legacy projects which we are still struggling with. In Maharashtra, overall the country is 50,000. That is one part. But then, talking about even new projects, there will be cases where a new project also can get stalled for a variety of reasons. The approving authority did not give approvals in time. Projects was launched in an area where there were no takers, people did not buy, we did not get financial institutions their total money for investor did come in. Whatever be the reason, the starting point, as I mentioned to you, has to be that the other stakeholders, especially financial institutions, should have that faith in RERA, that RERA will be able to solve the problem. Today, if the Act, the enabling provision under Section 8, if it doesn't talk about it, doesn't see the existence of financial institution, a financial institution will only go to SARFAESI or will go to the NCLT. Why will it come to RERA? So the starting point has to be where you give that confidence level to these people who matter. When a project gets stalled, who will be the person who will take it towards completion? It will be these two parties, the association of authorities and those unsold flats जहाँ पर भी पैसा लगा है from the financial institution. Unless you take both of them and maybe also the landowner, if he has some sort of interest in the project, unless these three are brought in under the ambit of the Act, I think he will not be able to have a plan. If you do that, then I see no problem. As I mentioned also in my talk, that apart from the three parameters that we are monitoring today, कितना project register हुआ, how many of those registered projects have been completed? Which means automatically that if the ultimate objective of the Act was to complete a registered project, if it has not got completed, it is the function and duty of the RERA authority to see how will you take it towards completion. And how will you take it towards completion? When you will make a blueprint, you will say that yes, in this manner, these are the low-hanging fruits, this I will complete in 3 years in this manner. RERA has taken the initiative to have a vertical where they have brought in a special officer also. But then you will also have to bring in those changes in the Act. There are the lawyers in this panel, they will agree with you. Unless you do that, you will not give the confidence to a banker or a financial institution to not go to SARFAESI or IBC and come to the
Sir, last 2 days we said in the newspaper that before the developer has to file a specimen development agreement and specimen development agreement before a registration is granted. Has this been implemented? Is it being implemented? That before registration, development specimen of the development agreement and specimen of the development agreement has to be filed. Then only registration can be granted. The last 2 days we said in the newspaper.
See, what he says, there is a specified format, model agreement format. Model agreement. There is a RERA also now prescribed model allotment agreement. Unless until those are in agreement with the RERA Act and rules, then only registration takes place. Whether this has started implementing, that's what his question is. Yes, it has started implementing. From the day one,
They were required to give a model agreement because at the initial period, the promoters were taking time. So initially declaration was taken that promoters will upload the model agreement, whatever he wants, within a certain time frame, so that the registration does not get stopped. So that was the leverage given. But now, unless until the model agreement is prepared, model allotment letter is prepared, and further now the RERA has come out with a circular. If there is any deviation, a declaration to the extent what are the clauses which have been deviated. Suppose the RERA allotment letter says you cannot deduct more than 2% of the consideration amount if the project somebody cancels the booking. So if he wants to make it 5%, he cannot do. But still, if he writes 5%, 10%, he should write that yes, I have deviated from this. So a certain declaration for deviation from the model allotment letter, deviation from the model agreement also he has to do. So then only the registration takes place, otherwise it does not take place. Yeah. Now CA Ashwin Shah wants to declare and announce certain program which is with the RERA practice also and MCHA credit wants to do. Please go ahead.
Before that, just to add to what sir has said on the blueprint for small project. Now, like what concept we have in IBC, where now the entire offense is taken over by insolvency professional. Something should come in MahaRERA also. There is a concept called RERA resolution professional. So that independent person is given a task because as a RERA, suppose there are 5,000, 6,000 projects, the resource available with RERA is limited. So they can come out with some such kind of idea where we have a RERA resolution professional who is an independent person and he looks after the project completion.
For your information, Ashwinji, in fact, in 2018, I had called the Insolvency Professional Association. So that time I had this in mind that we should also have a RERA Insolvency Professional who will do the initial handholding.
That's correct. He had come out with that circular, somehow that did not take proper shape. Maybe we'll have to improve on that.
So that would be a welcome step and that would be a practical step also. The announcement is that RERA Practitioner Welfare Association, Ramesh is also one of the committee members. We have joined hand with the RERA MCHI. We have signed one MOU with RERA MCHI wherein we are now going to conduct the many programs, as somebody has said, to have the authority awareness, even developer awareness and all these things. So in October, 13th to 16th October, the RERA MCHI has an expo, real estate expo at BKC, wherein for the first time, we are coming out with a novel idea of the RERA help desk. And that help desk would be monitored by beyond professional, wherein all the participants to this expo can seek the advice. There are nearly 400 projects which will be demonstrated. So they can come and certainly seek the advice on how RERA is beneficial to them, how RERA can be used before buying a house or even after buying.
Any other question? Yeah.
Is there a difference between conciliation and arbitration in terms of process and outcome?
My understanding is what is costlier, arbitration is much costlier than the conciliation part. Two, in fact, after arbitration award, the award is something which is not something which is agreed upon by both the warning sides. That's the most important difference between conciliation and arbitration. In a conciliation, it either succeeds or it fails. Arbitration doesn't fail. In the arbitration, if the both sides agree and then there is an arbitration award, good enough. But then even if suppose they don't agree, the arbitrator is the judge and he decides whatever he decides. So it is more akin to what is an order that is passed by a judge or by a person for judge.
Sorry. Just a clarification on that. So, in terms of being arbitrator, what is the value that he or she is providing?
I'll clarify. Basically, an arbitrator is a substitute for a judge. Judge, suppose it takes 5 years, arbitrator will solve your issue in 1 or 2 months. What sir is trying to say is that what is the difference between arbitration and conciliation? Arbitration, we can still call that it is a court case. The outcome is not dependent on you or the builder, it is dependent on the arbitrator who is the substitute for a judge. What is conciliation? Conciliation is a fancy word. What I tell people, call conciliation only as negotiation. you are coming to the table, builder is coming to the table, and flexibility is the keyword in conciliation. If you are ready to compromise on something, or if builder is ready to compromise on something, so your flexibility has taken place and you have negotiated a bit. If you are facing some problem, he was facing some problem, you have negotiated in the conciliation that ठीक है चल अभी ऐसे करते हैं, and the flexibility takes place.
And conciliator facilitates this negotiation.
Exactly.
Something like a mediation. तो ये आप ये छोड़ो ये ले लो ये छोड़ो ये
difference there between mediation and conciliation also. Mediator only facilitates, whereas conciliator, who is more expert in that field, actually suggests to both the sides what would be the best solution in the case.
Solves a problem
It is more proactivity in conciliation, and therefore in our conciliation forum, we have two experts, one a developer representative, one another consumer representative. And they facilitate in a more proactive manner. In a mediation, he facilitates the talking between the two so that they can come to some sort of agreement.
And they bridge the gap. So in a mediation, there is no contribution by the mediator.
Contribution is facilitation. You are making them talk. Because many things get resolved, many problems arise because you are not talking. As soon as you start talking, then I think many things get resolved.
And don't get stuck up on the technicality. Leave it like this, that arbitrator is a substitute for a judge for a faster court case. If you interpret it as
substitute for a judge either agreed by both the parties, a common judge, or through the appointment by the High Court.
I find that a little odd because my sort of understanding of arbitration was that it is in the interest of both the parties, and unlike a judge would weigh whatever is in his or her wisdom.
arbitrator will also wait.
We do just that.
More or less, see, broadly speaking, the duty or the outcome is same. An arbitrator, how he will handle the cases, broadly speaking, the same as a judge. The arbitrator is faster. Arbitrator is comes in the category of alternative dispute resolution. You don't want to go to the court because for XYZ reason, court is sometimes expensive, lawyer is expensive, court is taking more time. Arbitrator is to solve those problems, but still upholding the more or less the same judicial principles. You cannot say that, dear arbitrator, I want this outcome. Arbitrator will still be the judge of the matter. Outcome is not in your hand. In conciliation, outcome is in your hand. What do you want to compromise on? What does builder want? Flexibility is the keyword in conciliation.
Yeah, one or two questions we'll take because 12 o'clock is our time. We have already exceeded. Huh? Yeah. We'll extend by another 2 minutes.
Sir, if I can take 5 minutes, can you just add some things which I think will benefit the crowd?
Okay, sure. He had come with a presentation, but I said it's a parent discussion. Just let him come.
Give me 5 minutes. I'll just say something and then we'll just continue the session. See, the RERA authorities, they are the godfather of this real estate sector in the state. RERA authority has passed many circulars linking different departments of the government, linking stamp department, statutory department to the RERA, linking bank department, etc. But sometimes builders take complaint that prohibition is still an issue. So one of the biggest problems faced by builders is that there are too many government departments and there are too many permissions to run around for. RERA can officially step in many ways. Example number 1. See, consumer courts, they have summoned government officers to the court, they have summoned corporation officers, they have summoned insurance chairman. RERA can also do the same. If the builder is facing a problem from a government officer, let a strong summons be sent, let the person be made answerable to the court, and in that, if there is any wrongdoing of the builder, that will also come to light. Example 2, RERA can make a checklist for builders as well as corporation, a district-wise, ward-wise, a checklist can be maintained for easier things to be done. Then RERA can enforce the Right to Services Act against the government officers that why this prescribed time limit you have not complied with. Then next, RERA can also help with redevelopment. If society is going for redevelopment, let RERA give guidance. RERA has the slight infrastructure like the website and FAQs. Cooperative department has now started the digitalization so much right now. So let the initiative be started by RERA and then handover can be done for things like redevelopment. Also, RERA should start treating redevelopment disputes as a special category. Sometimes there are committees not properly constituted, sometimes the incoming outgoing promoter have disputes. So where stay on redevelopment should be granted, that redevelopment category should be dealt with RERA in a special capacity where required. And one of the biggest, the title for today is that what is the impact of RERA departments like corporation, urban development, they can join hands, they can come together, they can coordinate in their official capacity. If not some kind of authoritative compliance, even if they're talking in a persuasive manner, we can carry out a planned development of either a district or a city. Mumbai, I personally feel, has been the victim of unplanned development over generations and decades. We, with RERA, the powers that are given to RERA, we have the power to, so to speak, redevelop the whole city of Mumbai. Why we should have traffic jam issues? Why we should have overcrowded trains? Why we should have connectivity issues? If RERA and the other government departments, they join hands, we can transform. We do renovation in a house to improve the house. We can renovate the city, we can redevelop the city, so to speak, so that we can do a planned city or a planned township where infrastructure is in a very planned and organized manner. Another thing, that population density will not impact, it will not be done in the wrong way. So that is one of the biggest potentials of RERA. We have the power with RERA powers to transform unplanned city into planned city. So that is part.
Gautam sir, I am Rajesh Vidya. My query is regarding legacy issues. Now, for example, is there a protection mechanism in RERA for legacy issues pre-2016 with respect to redevelopment projects and pre-DA agreement? How can it come into the ambit of the Act? Can the OFA be bridged with RERA in a time-bound manner?
OFA is already sort of superseded by RERA. This is a central act. The second point regarding pre-RERA agreements, that also in fact various judgments of RERA has already been clarified. And even if you have done something with the retroactive effect of RERA, this will prevail. So whatever is presently in the act, that will prevail. Even if you had an agreement, we said something, that will be overridden by the RERA's new law. That much is very clear. First point of redevelopment, unfortunately, redevelopment, which is a very crucial issue in Mumbai, whether it is society redevelopment or even other redevelopment like cess buildings or slum, are still not under the purview of the Act, and something needs to be done to bring it under the purview.
Yes, sir, because it is giving them some leverage. Now, earlier he said he will do the project. Now he is saying, I may appoint the SPV to do the project.
And just for your information, because this I had taken cognizance of, and there is something which I had already written as a RERA chairman to the state government. The state government under the Act has 8 rules. The main rule, which is the registration rule, also defines what is a redevelopment project and also defines the phasing of a project. My proposal to the state government was that in a redevelopment project, no phasing will be allowed, and the redevelopment project essentially should be both the rehab component and the free sale component. This was a simple suggestion made, because even if suppose the Act section 3 says that there is an exemption if there is a redevelopment, this thing would have easily tackled this problem, because then any redevelopment, because the redevelopment cannot be only a rehab component, it has to have a free sale component, and if both together are treated as one phase, then you will have to register that with RERA. I still feel that the government should act on that, and if that is done, then I
Some
think
mechanism has to be developed for that.
no?
That pre-sale and post-sale flags. There has to be some uniform mechanism to treat both and one.
That's what actually it was suggested.
Yeah, he has agreed to your suggestion.
But it should come in before soon. Anybody start something.
We'll be back in
Yeah, so it has to come.
Society will be the co-promoter.
Yeah, right now, yes. Society is a promoter.
Self-development will come in the RERA.
Yes. Self-development also comes under RERA.
Today, if society redevelopment project is going for registration, because now commencement certificate there will be name of society and the developer. In the title flow also there will be the name of the society. So they are scrutinizing all the documents. And in one of our case, they have asked us to society also to name the promoter. Then the question under which head, the area selling or revenue selling? Because either the society is getting area or revenue, maybe some purpose or that it was suggested that you go for revenue sharing, and but society is now made.
Yeah. Yeah, it is a part of
Kind
that.
of revolution. Out of the total revolution.
Okay, thank you very much. So coming to the concept, today's impact of RERA in the real estate sector as well as to the allottees has been well covered by the panelists. I thank each one of them, especially Gautam Chatterjee who has taken on the time. And though the participants were limited, but the session was very live, interactive, and I think we have tried to cover from the simplest question from the allottees point to the complex situation of a short project with the NCLT's intervention. I think this has taken us to a proof. And today, yes, sir, today as a conclusion, I would request one or two things from you. Today that you have honored. One is, we would like to come out with a case study on the stall project. There are nearly 15 to 20 case studies I am personally aware. Maybe there may be 100 case studies. Out of that, around 7 case studies I myself have done, maybe another 10, 12 I am aware who has done. But there may be more than 100 case studies which have already been done. These case studies, not only of Maharashtra, but other states like even Gujarat, UP, and of course Supreme Court judgment of Amar Pali, that also may give some highlight. And there are some regulations which RERA has already discussed and they are in the process of coming. So one case study is on the stall project where we may need your help and contribution. Second is about the regulation which maybe RERA has said that you coin a regulation, give it to us, then we will try to work on that, improve on that for the stall project. So these are the two things which we may request.
So I would feel on redevelopment you should also work.
Yeah, redevelopment.
Because that's the major distress.
Redevelopment, how to take ambit of it. Okay. So with this, I think 3 takeaways, and we will definitely work towards it. Thank you very much, and appreciate your presence today. Though it is Sunday and